My name is Leah Kosokowsky. I'm the Chief Executive Officer of the Law Society of Manitoba. And with me is Noelia Bernardo, who is our equity advisor. Noelia and I have both been with the Law Society for many years, so we hope that you find today's session informative and helpful to you. So let's start by talking just briefly about what the Law Society does generally. We protect the public by regulating lawyers and the delivery of legal services throughout Manitoba. And we do that in a variety of ways. We decide who can offer legal services in Manitoba. Not everybody or anybody can just say, hey, I'll represent you in court, or I will draft a will for you. Only people who are registered and licensed with the Law Society can deliver legal services here. And so we educate those lawyers. We educate them before they're licensed to practice and throughout their legal careers. We set standards of practice for lawyers. We have specific rules they must follow, and we have a code of professional conduct that applies to them throughout their careers. And we enforce those rules and those standards through our complaints and at times our discipline process. And finally, we also compensate clients through our insurance fund or our reimbursement fund if a lawyer's conduct has caused their own client some kind of financial loss. The first is your rights. When you walk into a lawyer's office and you ask them to provide legal services to you, what can you expect from the lawyer? What are the standards that we require of them when they're delivering legal services to you? And then secondly, after we talk about what those rights are, there may be occasions where you have some difficulty with your lawyer. And in those cases, we want to talk about how the Law Society can help you and help the clients that you serve.
When you hire a lawyer, you're not only hiring someone with legal training and skills, but you're also hiring a professional who must follow strict rules of conduct. These rules are called the Code of Professional Conduct, and they outline a lawyer's ethical duties to their clients and to others. They ensure that lawyers act honestly, respectfully, and professionally. The Code of Conduct is a public document, and you can find it on our website if you'd like to read it in more detail. 11 key client rights to help you understand what you can expect from your lawyer. So you have the right to expect good service from your lawyer. This means the lawyer should be professional, pay attention to details, and handle your legal matter properly. Good service includes clear communication, timely responses, and making sure you're kept informed throughout your case. Quality of service is important. It builds trust between you and your lawyer and ensures that your legal issue is managed effectively. Let's look at some specific examples. Your lawyer should provide you with regular updates on the progress of your case, so you always know what's happening. They should respond to your reasonable requests for information and make sure that your concerns are addressed. Your lawyer should reply to your calls or emails without unnecessary delay, so you're not left waiting for important updates. Now, what is a timely response? That depends on a lot of factors. For example, if you were to email your lawyer asking for a general update on your case, a case that's been in progress for a while, but there are no deadlines or court dates upcoming, a response within several days or even a week might be reasonable, as your lawyer may be in court, needing time to review your file or waiting for some developments before providing you an update. If you were to get a legal notice from a court or other party requiring you to provide a response within 24 hours, or you could have serious consequences, then if that same email or call to your lawyer, a same-day response would be reasonable because quick action is needed to protect your rights. So urgency is just one example of the factors that we look at when we're trying to understand what is reasonable in the circumstances for a response. A good lawyer is going to prioritize urgent matters while also keeping their clients informed about when they can expect a response for non-urgent requests. Another example of a good quality of service or quality of service you should expect is that the lawyer works promptly on your case, avoiding unnecessary delays to keep things moving smoothly. Lawyers should do what they say they're going to do, such as filing paperwork or contacting other parties or completing promised tasks. And finally, the lawyer should be polite and respectful. Your lawyer should treat you with courtesy and respect at all times. This duty applies not just to the client, but to everyone involved in the case. That includes the court, witnesses, opposing lawyers, and even the opposing party in your matter. A lawyer's professional behavior maintains trust and honesty in the legal process, so it's very important. The next of the client rights that we're going to cover, number 2, is competency. It's another important right, your right to a competent lawyer. This means your lawyer must have all the skills, the knowledge, and the experience needed to handle your legal matter properly. Competence is important because it ensures that your case gets the attention it needs and is managed the right way. A competent lawyer understands the relevant laws, stays up to date on legal changes, and uses their knowledge to protect your interests. This right helps to ensure that when you hire a lawyer, you're getting someone who's qualified and capable of handling your case. To better understand competence, let's look at an example. If you hire a lawyer to prepare a will and then later ask them to handle a family law matter, such as a separation or divorce, you should be able to trust that if the lawyer says, yes, I can act for you, that the lawyer has the right knowledge and skills to do a good job. Think of it like this. If you're seeing a doctor, your family doctor, to treat a sore throat, and then you have a heart condition, you'd likely see a specialist for the heart condition. This applies to lawyers. They should only take cases they are trained and experienced to handle. If a lawyer isn't prepared or doesn't have the right training, they must tell you that and help you find the right legal help. Competence means your lawyer's qualified, prepared, and capable of handling your legal matter properly. The next right we're going to cover is number 3 on the list, is honesty and candor. As a client, you have the right to expect honesty and openness from your lawyer. This means your lawyer must always be truthful and clear with you, making sure that you know all of the important facts that could affect your case. Your lawyer should tell you about any information that might affect your interests. This includes any potential problems, new developments, or any risks that you need to be made aware of in order for you to make informed decisions about how your matter should proceed. An example is if your case involves an urgent matter and there's a chance of a delay in meeting a deadline, your lawyer should be upfront about the timeline. This way you're prepared and understand any potential effects on your case. It's important to know that your lawyer also has a duty of honesty and openness towards others, including the opposing lawyer and the court. This duty of honesty and candor maintains trust and integrity in our legal process. So your lawyer should never withhold important details or mislead you, and they should always make sure that you have the full picture of your case, keeping you fully informed and involved in your matter.
Your lawyer must give you clear, informed, independent advice and get your directions. Now, that seems pretty clear, but sometimes that's a difficult discussion. If you're in your lawyer's office and you want to proceed with something in a certain way and the lawyer thinks it's not a good idea based on the law as they know it, then they are obliged to give you that hard advice sometimes. And we do occasionally get telephone calls from clients who say, I think my lawyer's on the other side because they're telling me these things. And we say, nope, they're obliged to give you that hard advice sometimes. But even once they do give you their advice on your matter, then it's you who makes the decision as to what will happen. And that's very important. And I'll give you an example of that. Let's say you have been, your employment has been terminated and you're suing your employer for compensation. And so let's say that the employer's lawyer makes an offer to your lawyer to settle. We're going to pay your client a certain amount of money to stop the lawsuit. If the lawyer thinks it's a bad offer, they can't just say to the lawyer opposite, oh, that's a lousy offer. We don't accept it. We're carrying on. They can't do that. They have to come to you. They have to say, listen, we've received this offer. Here are the benefits of the offer. Here are the risks of not accepting it and carrying on. They need to give you all of that clear advice about what the risks and benefits are, and then it's up to you to make the decision. You may decide that you want to end the litigation and accept the offer. Number 5 is related to that. It's settlement. Your lawyer actually has a professional obligation to advise you and encourage you to settle or reach a compromise when they think it's reasonable to do so. And they should also discourage you from starting an action or continuing one that is unhelpful and perhaps an abuse of the legal system. And so let me give you an example of where they might encourage you to settle. Your next door neighbor causes damage to your fence. It's going to cost you $500 to fix your fence. You go to your lawyer and you go to the neighbor and say, I'd like you to pay for that. And the neighbor says, nope, it's not my fault. I'm not paying. So you go to a lawyer and say, I want to sue them. I want to get my $500 back. The lawyer should be saying, yep, you've got a good case. We can probably get your $500 back, but it's going to cost you thousands of dollars in legal fees, in court costs. It's going to cause you stress and aggravation. And so what I really encourage you to do is go back to your neighbor and say, perhaps we can split the cost. And that there, you don't get fully compensated, but it saves you money and stress and aggravation in the long run. Number 6 is confidentiality. Your lawyer must keep confidential all information about your business and affairs. And so when you walk into a lawyer's office and you share information with them, they cannot even tell somebody else that you've hired them without your permission. Sometimes you have very sensitive information that you have to share with your lawyer about your matter. Sometimes it's very difficult to talk about and share that information. When you do, then you know that it will be kept confidential and will not be shared with anyone else without your permission. Even after your relationship with your lawyer ends and you're no longer their client, they still must maintain your confidentiality. It survives the end of the lawyer-client relationship.
So number 7 of 11 on our list is the right against conflicts of interest. That's another important right. This means that your lawyer cannot represent you if they have competing obligations that could affect their ability to put your interests first. So your lawyer is to be fully loyal to you as a client, focusing on your case without any outside influences. Conflicts of interest protect your privacy because your lawyer cannot take on another case if it risks revealing your confidential information to someone else. These rules against conflicts of interest make sure that your lawyer is fully focused on your case without any outside factors that could affect their judgment or loyalty to you. To help explain a conflict of interest, we've provided some examples where a lawyer wouldn't be able to represent someone due to divided loyalties. If, for example, you were in a car accident, you and a friend both wanted to make a claim, but you disagreed on who was responsible, and you go to the same lawyer, to help you. Well, that lawyer could not represent both of you because the lawyer would have divided loyalties. In order to advise one of you, that advice could negatively affect the other person's case. So in that situation, you would each need to get separate counsel. Similarly, with a divorce, you and your spouse can't have the same lawyer acting for you because your interests are separate. There's property, there's support, there's occupancy of the home, all of those things. You and your partner may have different interests, and because of that, the same lawyer can't act for both of you. These rules against conflict of interest protect you by ensuring that your lawyer is only focused on you and working on your best interests. The next client right is the client's right to have legal services in English or French. So this is a right that your lawyer should be informing you of so that you can choose the language that you're most comfortable with. If you're dealing with a family breakdown and there's a custody dispute, if you prefer to speak French to be fully understood and to understand what your rights are and your obligations, you are entitled to find a lawyer who speaks French to make sure that you can participate fully in the advice and the instructions that you give to the lawyer. This is all about comfort and clarity. You should never feel confused or left out because of language. For French-speaking clients, there's an organization called Infographic Manitoba. They provide free legal information and can connect you with French-speaking lawyers and resources. If you speak a language other than English or French, the Community Legal Education Association has a directory of lawyers who speak various languages. You can also contact the Law Society, as we may be able to help connect you with a lawyer who speaks your language. And again, this matters because getting legal services in the language that you understand well helps prevent misunderstandings and ensures that you are fully informed about your case and your legal options. The next right, number 9, is safeguarding of property and money. So as a client, you have the right to trust that your lawyer will handle your money and your property safely and responsibly. Lawyers don't just manage cases, they also manage client money in many cases. That's why strict trust accounting rules have been created and exist to protect you as a client. So those rules require your money to be kept separate in a special trust bank account for client funds. It's never mixed with other money belonging to the lawyer or the law firm. These rules protect you by ensuring that your money is only used as you direct, preventing mistakes and helping to prevent misuse. The Law Society has an audit department that conducts regular surprise checks to confirm that the lawyers are following these rules. This helps to safeguard and to make sure that your lawyer is managing your funds properly, keeping them secure and available when you need it. And these rules provide peace of mind to clients as well. So if you're buying your first home and you've been saving for years for a down payment, you can trust that if you give this money to your lawyer is going to handle it properly. They're going to deposit it into that special trust bank account. They're going to keep it separate from their trust funds, and they're going to disperse or pay out those funds as you direct so that your purchase can occur. You can feel confident with these rules that your money is protected, that's managed responsibly, and that lawyers are being monitored to make sure they comply with rules.
Number 10 is fair and reasonable fees. So what does that mean? That means when you hire a lawyer, they need to tell you how they're going to charge you and what they're going to charge you for legal services. And if you have a criminal matter or you have a family law matter, your lawyer must tell you if they think you might qualify for legal aid, so that legal aid can be covering the legal costs and you're not paying the lawyer privately. So lawyers can charge for their services in different ways. One way is a flat rate. That means they're saying to you, I'm going to charge you X dollars to prepare your will. to attend a bail hearing, to do all kinds of things. And it doesn't matter if it's going to take the lawyer 1 hour to do it, or if it's going to take them 3 hours to do it. They're saying, this is what I'm going to charge you, and you can decide whether or not you want to hire the lawyer to do that work for that amount of money. Some matters, some legal matters, go on for a long time. And in that case, you'll often find the lawyer charges an hourly rate. So what they're saying in that case is, my hourly rate is X dollars per hour. And what I'm going to do in your file is I'm going to keep track of the time that I spend working on your case. I'm going to record it, and I'm going to multiply that by my hourly rate and bill you regularly so that you know what I've been doing and the time that I've spent doing it. And then you have a running tally so that you're not surprised at the end of the case about what the lawyer wants to charge you. In either of those cases, the lawyer might say at the beginning, I want a deposit for my fees. So we call that a retainer fee. And Noelia has just spoken about the safeguarding of your money. If they take a deposit from you or a retainer, they have to deposit it into a special trust bank account, and they cannot take that money into their own bank account until they've done the work and they've sent you a bill for that work. There's another way that lawyers can charge fees. It's called a contingency fee. It's not as common. It's used more often where the client might have a novel case and there's some risk in the lawyer taking it on, because what they say to the client is, I'm not going to charge you any legal fees at all if we lose. But if we are successful, then I will charge you a percentage of what you're awarded at the end by the court. And sometimes that fee will be higher because the lawyer is taking the risk that you won't be successful and they'll have spent a lot of time on the file without getting paid at all. In those cases, there are special rules about having the agreement in writing. And that agreement also has to refer to the court rules about your ability to have the fee reviewed at the end of the day to see that it was fair and reasonable. One other way that the lawyers can charge for legal services is what we call unbundling. And you'll find sometimes that a client can't afford a lawyer for their case, let's say a family law case, and they're acting on their own, but they say, I'd like you to just prepare this document for me that I need. And so you can come to an agreement with a lawyer that says, okay, we'll do just this one discrete part of your case and charge you this much for it. Another way might be, you're going to appear in court on your own, but you'd like the lawyer to spend some time coaching you on what you're going to say in court. So that's what we call unbundling. But in any of those arrangements, at the end of the day, the fee needs to be fair and reasonable for your case.
We've come to the last of the key client rights, which is the withdrawal of services. So when it comes to ending a lawyer and client relationship and when a lawyer may withdraw from representing you, that is one of the rights that you have to know. So just like any working relationship, if it's not a good fit, you have the right to end the relationship with the lawyer at any time. Whether it's because of slow responses or you feel like the lawyer isn't meeting your needs or you just don't connect with the lawyer. You can always choose to find someone better suited for your case. You also have the right to know if your lawyer plans to stop representing you. This ensures that you're not left without support, especially if there are important deadlines coming up. But unlike the client, a lawyer cannot just walk away without a valid reason. The lawyer has to give you enough time to adjust and explain why they're stepping away from your case. Some of the reasons a lawyer might stop acting for you as a client is if there's a conflict of interest that arises. So, for example, there's a new development in your case and it's going to create a conflict with another client that the lawyer's already representing. The lawyer may not be able to continue acting for you. Sometimes it could be there are communications issues. If the lawyer is unable to get instructions from you, or there's miscommunications that make it very difficult to continue working together, the lawyer may decide that they must step away. Another example is if continuing to act for you would require the lawyer to violate professional obligations that they have. The lawyer would have to step away. But they can't just step away. They have to also explain why they're stepping away and give you that time so that you can arrange for new counsel. So these rules are set out to protect both you and the lawyer, ensuring that there's a fair and professional way for you to end the relationship. They make sure that you as the client, you're not left in a difficult position without legal support. And they ensure that lawyers continue to follow their professional responsibilities. So if your lawyer needs to stop working on your case, there are specific steps that they must comply with to make sure you're treated fairly and not left in the lurch. Your lawyer has to give you a written explanation for their decision to withdraw, so there's no confusion about why they're stepping back. This written notice keeps things open and clear, so that you're fully informed about what's happening and why. The lawyer needs to tell you about any important dates coming up, such as court deadlines, so that you're not caught off guard. This way you have time to make necessary arrangements to keep your case on track and protect your interests. Your lawyer must also give you a detailed breakdown of any money they're holding for you and provide a statement of account or a bill if there are any final charges. This ensures that you're aware of all your funds and have them available for the next steps in your case. If you hire a new lawyer, your current lawyer is also required to cooperate and work with the new lawyer to transfer your case. This helps to make sure that the handover is as smooth as possible so that your new lawyer can get up to speed without unnecessary delays and costs to you. These steps protect you by ensuring that your lawyer withdraws. If they withdraw, they do so responsibly, allowing you to continue your case without disruption.
Now we're going to go into, well, how can the Law Society help if you're experiencing difficulties with your lawyer and you think that your rights are not being met? And as you can see on the screen, we have 6 key areas, and we'll go through each one in turn.
As the equity advisor, I support people who are experiencing unfair treatment or harassment in legal settings. My role is to help ensure that lawyers uphold professional standards and treat people fairly and with respect. Now, discrimination happens when someone's treated unfairly because of factors like race, gender, age, background, nationality. And discrimination can create barriers and limit opportunities. Harassment, well, that includes words or actions that make someone feel uncomfortable or embarrassed or humiliated. And when it's based on personal traits, that harassment may also be discrimination. Lawyers must follow professional rules that require them to treat people fairly and with respect. So people might contact me if they feel a lawyer isn't treating them fairly because of their race, gender, or background. If they're uncomfortable with a lawyer's comments or behavior, something that seems inappropriate or offensive. If they feel pressured or judged based on their personal characteristics that have nothing to do with their case. Or if they feel excluded, disrespected, or unsafe in a legal setting. I provide support and guidance for people facing these challenges and help ensure the legal profession remains fair and respectful. And if you need my help, you can contact me by contacting the Law Society's general line, or you can email me. My email address is equityadvisor@lawsociety.mb.ca. Another way the Law Society can help you when there are difficulties is through our complaints resolution department. An important part of what they do is to try to help when clients have concerns about a lawyer's behavior to resolve those issues early in a friendly, informal way so the problems don't escalate and you don't need to file a formal complaint. And some of the concerns they can help you with informally are when there's a lack of communication, unexpected delays, you're unclear on the lawyer's billing or fees, if there are misunderstandings about what the lawyer is saying, or if you're feeling dismissed by your lawyer's not listening to your concerns or answering your questions. The Complaints Resolution Department will help you by providing practical tips to help you with these problems. And if needed, they can even reach out to the lawyer on your behalf to discuss the issue to try to assist you in that way. They only do that if you request that they do so. Otherwise, your contact with the Law Society's Complaints Resolution Department for some informal assistance is completely confidential. So they will not be letting your lawyer know that you've called for help unless you want them to contact the lawyer on your behalf. This process ensures that clients feel heard, supported, and confident that they can handle their concerns either directly or with some informal assistance through the Law Society. But the informal process doesn't always work or is not really an option in some circumstances. And for the more serious concerns that can't be resolved informally, clients can choose to file a formal complaint. So that can be done. We have a complaint help form on our website that you can print off and email or mail to us or drop off. You don't have to complete the form. You could just provide us a letter or email as long as it has sufficient information. They can consider that a complaint and proceed. Sometimes the Law Society receives anonymous complaints. And if they're serious enough and there's enough information, the Law Society can investigate those concerns. But the investigation might be limited by not being able to speak to whoever it was that made the complaint and get certain information that might be needed. If a client struggles to write a complaint, we can certainly help. And sometimes that assistance will be depending on what the struggle is. It could even include writing out the complaint based on your over the phone or in-person instructions or information, and then sending it to you for review or reading it to you before it's concluded. Once a complaint is filed, the information is reviewed and an investigation will be undertaken if there's enough information that the department determines that there may be a concern that the lawyer has breached their professional obligations to you. If they need more information, they'll contact you. If they investigate, the lawyer must respond to the complaint in writing, and then that information is shared with you so that you are given an opportunity to provide a further reply or comments to the lawyer's response. Once all of the relevant information is gathered and assessed, the department will decide whether there, in fact, has been a breach of the lawyer's obligations and what action should be taken, or if they find that the lawyer has followed the rules, they'll send you a letter explaining why no further action will be taken. If the lawyer has breached the rules, then depending on how serious and what the lawyer's history is, then they will determine what steps need to be taken. That can range from a written reminder, recommendations, seeking a written undertaking or promise from the lawyer, recommending additional training for the lawyer, or in the most serious of cases, recommending that the lawyer be charged with professional misconduct. That takes me to the discipline proceeding. When a lawyer is charged in those serious cases, the matter is transferred to the discipline department. And the discipline department is there to protect the public by ensuring that the lawyers who fail to meet professional standards are held accountable so that harm is prevented to both clients and the justice system. Lawyers must meet these obligations, and if they don't, the discipline process reinforces the standards and helps ensure that lawyers practice responsibly. The discipline process is there to preserve the public's confidence in the legal profession. We rely on the trust of the public And when misconduct happens, a clear and fair discipline process will help us maintain confidence in the profession by showing that lawyers are not above accountability. Steps that can be taken if a lawyer is found guilty of professional misconduct include anything from a formal warning, a financial penalty, restrictions on what they can practice and how they can practice. And in the most serious cases, lawyers can be suspended, which means they're temporarily banned from practicing law, or ultimately the most serious of the consequences is disbarment. That means the lawyer's license is revoked, permanently removing them from the profession. Transparency in our discipline process is key, and discipline decisions are made public on the Law Society's website. Anyone can read them. Practice restrictions and suspensions are also listed on our website, and we have a lawyer lookup tool when you're looking for lawyers that you can search any lawyer by name, and not only will you get information about where they practice, how long they've been practicing, but you'll also see if they have a discipline history, any restrictions on their practice, or if they're currently suspended or disbarred. Discipline ensures that the legal profession remains accountable. I can't emphasize that enough. And it upholds the trust and responsibility placed in the Law Society by the public.
I want to talk a little bit about financial protection. And I indicated earlier that all lawyers in Manitoba have to be licensed with the Law Society. That also means that they have to be insured, so that if you walk into a lawyer's office and ask for them to act for you, then you can know that they carry professional liability insurance with the Law Society, so that if they make a mistake, and it does happen on occasion, that causes the client a financial loss, then the client can make a claim to the insurance department to be compensated. And also, Noelia talked about the rules that we have that lawyers have to follow to protect clients' monies. There are rare occasions where the lawyers don't follow the rules and in fact take the client's monies inappropriately. In that case, we have a reimbursement fund into which every lawyer who practices law in Manitoba pays into this fund every single year that they're practicing. And a claim can be made against that fund for compensation in the event that a lawyer has improperly taken a client's money. The last one on our list about how the Law Society can help is how we can resolve fee disputes. So we talked about the fact that lawyers' fees have to be fair and reasonable. So if you get your bill at the end and you think, geez, I don't think this is fair and reasonable, you can ask the Law Society to begin our informal process of reviewing the fee. And what happens there is if the client and the lawyer both agree to participate in this process, we appoint an arbitrator who will either reduce the fee or uphold it. And after both the client and the lawyer get a chance to indicate why they think the fee is fair or unfair. To participate in that process, both the client and the lawyer have to agree, and both the client and the lawyer have to agree to be bound by the decision of the arbitrator. And the great part is that it's free. Having said that, if the lawyer doesn't agree, there is a process through the courts, which is very similar, an informal process to review the fee. And in that case, the lawyer can't refuse to participate, but there is a filing fee for the client to start the process. One way or another, this is a method by which we can determine if the fee is fair and reasonable. I could tell you this, though, time is money for lawyers. If you're unhappy with the fee, if you think it's not fair, we really encourage you, raise it with the lawyer directly, because I think they would, they have an obligation to tell clients to settle something or compromise something. Well, they understand that obligation. And there are many cases where they'll say, okay, I'll have a look at it and say, okay, I'm prepared to reduce my fee. And so we always encourage clients to speak to the lawyer if they're unhappy with the fees that have been charged. three things that you can take away from our presentation. One, what the role of the Law Society is. We are here to protect the public and to assist you if you're having difficulties with your lawyer. Secondly, we set standards of practice that lawyers must abide by. And we hope that through our presentation, you know that some of those standards are and what your rights are when you hire a lawyer. And then finally, if you do have concerns, contact us. We are here to assist, and you can see that there's some contact information there for you.